Hey, this is Alex Zouzlas, author of the book Courtroom Confidential, Everything They Don't Want You to Know About Lawyers and More. The deportation of Kilmar Abrego-Garcia is a political hot potato. Today, I'm going to discuss a common sense, non-political solution to the situation. Just a reminder, I'm not giving legal advice. I'm just analyzing the situation and suggesting a more practical solution to any I've seen to date. When he was picked up by ICE, Mr. Abrego-Garcia, a citizen of El Salvador, had been living in the U.S. for about 14 years. He was married, had 3 children, one of whom is autistic and nonverbal. He worked construction, and Mr. Abrego-Garcia didn't have a criminal record. He was deported to El Salvador under the Alien Enemies Act and imprisoned there, presumably because of his alleged affiliation with MS-13. It looks like Mr. Abrego-Garcia has been moved from the notorious Secot prison to a less harsh institution. Though Mr. Abrego-Garcia was in the U.S. illegally and he was found to be deportable by 2 immigration judges, he was allowed to remain in the country under an order withholding deportation due to his claiming that his life would be in danger from a rival gang if he was deported. Mr. Abrego-Garcia denies the government's claim that he's a member of MS-13, but as I'll discuss, given his current circumstances, that point is irrelevant. After Mr. Abrego-Garcia was deported, a federal district court in Maryland issued an injunction ordering the government to facilitate and effectuate Mr. Abrego-Garcia's return to the U.S. no later than 1 minute before midnight on April 7th. The government then applied to the U.S. Supreme Court to vacate the injunction. The Supreme Court, in turn, entered a temporary stay of the district court's order and on April 10th entered its order granting the government's request to set aside the April 7th deadline for Abrego-Garcia's return to the United States. Although the Supreme Court found that the district court's order properly required the government to facilitate Abrego-Garcia's release from custody in El Salvador and to ensure that his case is handled as it would have been had he not been improperly sent to El Salvador, the court ordered the Maryland District Court to clarify what the intended scope of the term effectuate means. The Supreme Court noted that the term is unclear and that it may exceed the district court's authority. The Supreme Court ordered clarification with due regard for the deference owed to the executive branch in the conduct of foreign affairs. And that's the key to the case. When the court talks about deference to the executive branch, the president, it's really saying whether the president correctly invoked the Alien Enemies Act, and if he did, whether a court has the authority to interfere with the president's authority to deport certain gang members under the act. I would note that in its 1948 decision in Ludicky versus Watkins, the Supreme Court upheld the Truman administration's extended reliance on the Alien Enemies Act, even though the purpose for the government's originally invoking it, World War II, had ended. The court reasoned that it was not the judiciary's place to second-guess the president on political matters. It's also well settled that the president is the sole organ of the federal government in the field of international relations. The Alien Enemies Act of 1798 is a wartime authority that allows the president to detain or deport natives and citizens of an enemy nation. The law permits the president to target these immigrants without a hearing based solely on their country of birth or citizenship. Moreover, the political question doctrine could prevent courts from striking the president's use of the Alien Enemies Act. That doctrine cautions courts against addressing issues that fall within the president's constitutional duties and which lack judicially manageable standards for resolution, which, I'll discuss, appears to be the case with Mr. Abrego-Garcia. In the 90s, courts relied on the doctrine to dismiss claims that the Clinton administration was permitting a migrant invasion of the United States in violation of Article 4 of the Constitution. Courts have also held that the president's recognition of a foreign government is binding on courts, so this could allow the president to invoke the Alien Enemies Act based on a migrant invasion or predatory incursion perpetrated by a cartel alleged to be acting as a de facto foreign government. In other words, the foreign enemy doesn't have to be a foreign country like the Netherlands or Luxembourg. It can be an organization with the purpose of flooding the United States with narcotics, illegal aliens, and criminals, all of which causes great harm to the United States. So the answer to the question whether deportation under the Alien Enemies Act falls from the powers of the president seems to be yes. El Salvador is not an enemy of the United States. Instead, President Trump has referred to members of gangs such as MS-13 and Tren de Aragua as a hybrid criminal state invading the United States. The president doesn't have to wait for congressional approval to invoke the act where it's based on a threatened or ongoing invasion or predatory incursion rather than a declaration of war by Congress. So these factors that I just discussed seem to militate in favor of the president's use of the Alien Enemies Act to deport members of MS-13 and Tren de Aragua. What then is the government obligated to do under the Supreme Court's order? Well, the order tells the president that the government has to facilitate Abrego-Garcia's release from custody in El Salvador. But what exactly does that mean, and what authority does the United States have to dictate to El Salvador who can and who cannot be released from El Salvador's custody? It's also important to note that El Salvador, not the United States, put Abrego-Garcia in prison. The problem is the term facilitate also seems to be vague because there's no definition or guidance as to what acts are encompassed in that term. Furthermore, what authority does the United States have to go into El Salvador and remove one of its citizens to the U.S.? There could be a treaty or agreement that allows that, but what if El Salvador simply says no? The courts here have no authority or jurisdiction over El Salvador. Is the United States supposed to send in a SEAL team or two to extract Mr. Abrego-Garcia from the country he's a citizen of? I don't think so. There's no doubt that Abrego-Garcia had been living illegal in the United States and he was subject to deportation. The issue seems to be Abrego-Garcia was deported without there being notice and an opportunity to be heard on the matter of the continuing need for the order withholding deportation. Can that be addressed without Abrego-Garcia's being in the United States? Yes. The hearing could be conducted via Zoom or another such platform, with a U.S. immigration judge presiding over the hearing, lawyers for the government and Mr. Abrego-Garcia participating, and the issue being interpreted and resolved under our federal immigration laws. The government wouldn't even have to prove that Abrego-Garcia is a member of MS-13. Mr. Abrego-Garcia's membership in MS-13 is why El Salvador locked him up. It has no bearing on whether or not he was deportable. All the government would have to prove is that there is no longer a basis for the previously entered order withholding deportation because the threat that served as the basis for the order no longer exists. That's probably the most logical resolution to this situation. Those are my thoughts on the Abrego-Garcia case. Please post any comments you have. They always generate interesting discussions. If you're a lawyer considering hiring me to research and draft pleadings under your supervision, my contact information is in the description to this video. Thanks for watching, and I'll see you next time.